Hi, everyone. Thanks so much for joining us today as we mark the return of our National Labor and Employment webinar program from our summer hiatus. My name is Andy Pushalik. I'm the National Practice Group Leader for the Dentons Canada Labor and Employment Group, and I sit in Toronto. I'll be your moderator as well as the speaker for today, and I'm very, very pleased to be joined by colleagues across the country. We have Jeff Bastien in Vancouver, Nicolas Séguin in Montreal, and Kristi Wong in Calgary. Today, we're going to highlight those Canadian employment and labor case law and legislative developments that you may have missed over your summer vacation. We're going to work from east to west, starting in Quebec, then through Ontario, over to Kristi in Calgary before finishing with Jeff. So with that, I wanted to turn things over to my colleague, Nicolas, who's in Montreal, to discuss the latest developments on labor and employment law in Quebec. Nicolas, over to you.
Thank you, Andy. So hello, everyone. It's a pleasure to be here with you today to discuss the employment and labor highlight of the summer season in Quebec. My name is Nicolas Séguin, and I'm a lawyer in the Montreal office in the Employment and Labor Group. And so the first thing I'd like to talk about is the Quebec government's adoption of a bill to regulate child labor. The name of the bill is an act respecting the regulation of work by children. And although most of the bill came into force on June 1st of this year, there are several provisions that came into force very recently on September 1st. And so I think it's important to be familiar with their effect on employer. It should be noted that prior to the adoption of this law, Quebec had no minimum working age. And it's important to understand also that this law was introduced in the context of a labor shortage, since companies were increasingly calling on young workers to fill certain positions. The government therefore decided to regulate this situation with this law. And so here's a summary of the key points that may be relevant to you. And so as of June 1st, the minimum age for access to employment in the province of Quebec has been set at 14 years old. And it is now prohibited for an employer to hire a child under the age of 14. The regulation provides for certain exceptions, but the employer must keep in mind that he needs to obtain written consent of the person having parental authority over the child by using the form that is established by the commission, which we call the CNSST. So it's really important to use that particular form. The form must be kept by the employer and must also set out the main task, maximum number of hours of work per week, and also the periods when the child is available for work. If any of these elements change, the employer must obtain a new written consent. As I told you, there are certain exceptions to the prohibition of work by children under the age of 14. Some of them are the following. So a child can work in a family enterprise with fewer than 10 employees. A child can also work in a nonprofit organization having social or community purpose. Or for example, a child working in an agricultural enterprise with fewer than 10 employees. But we must keep in mind that the general rule that the children under the age of 14 cannot work in Quebec since this summer, basically. Since September 1st, so very recently, an employer may not require a child subject to mandatory school attendance. This is basically a child who is between the age of 14 and 16-year-old to work more than 17 hours per week or more than 10 hours from Monday to Friday. It's good to note that this prohibition will not apply to school holidays during the summers. And so this concludes the summary of this law. It's a short summary, but I think it's highlights the important aspect that the employer must keep in mind when they hire a child. And so we can move on to the next slide, please. Good, thank you. So the second thing I want to address with you is I would like to draw your attention to a decision that has been rendered during the summer that I feel is an important reminder of the importance given by the court to issues of psychological harassment in the workplace. This issue keeps taking more and more place, and the courts are pretty severe about it. So I think it's good to talk about, there's a decision which is called Couture versus Clean. It's a decision from the Superior Court of Quebec, which, as I told you, is a great reminder of the role that employer must play in stopping and preventing harassment in the workplace. So in that particular decision, the plaintiff holds the position of operation manager and has been with the company for 39 years. After receiving numerous complaints from employees in the space of just a few weeks, alleging that the company's operation manager was acting in an unacceptable manner toward them, but also toward customer, the employer mandated an external investigation firm to shed light on the situation. It should be noted that during this period, the employer suspended the employee for the duration of the investigation. The report submitted by the firm established, amongst other things, that the executive frequently made disrespectful comments about employees, management, women, and also people of different nationality from himself, in addition to behaving inappropriately towards some of the employees in particular. Just to give you an idea of the kind of behavior that this employee had, here are a few examples stated in the report. So he was constantly reminding sales representatives that they are simply salespeople, just to degrade them. He was also making comment that he doesn't like the employees to be in a good mood when they were in the office, and he was making disrespectful comment towards female staff. And so based on the result of the investigation report, the employer decided to terminate the employee's employment immediately without giving him time off or any kind of compensation, despite the fact that, as I told you, he had been with the company for almost 40 years, which is pretty considerable and which is usually playing a key role in this kind of situation. And so, believing that the employer should have managed the situation by imposing a lesser measure, and that the reason given in support of his dismissal did not constitute a serious reason within the meaning of the Civil Code of Quebec, the executive instituted a legal proceeding against the employer. Faced with that situation, the Superior Court decided to dismiss his claim in its entirety, concluding that there was no doubt that he had been dismissed for cause. The court stated that the manager must be a role model for others and that his action must reflect the company's values. The judge pointed out that given the employer have a legal obligation to protect the health, safety, and dignity of their employees, and to guarantee them a workplace free of harassment, an employer who discovered that the person in position of authority is acting in a toxic or humiliating and inappropriate manners towards employee is justified in reacting promptly by taking drastic measures. And so furthermore, the court pointed out that the principle of progressive sanction does not apply to people at the top of the pyramid, and that even if it had, this was not a situation that could be corrected by disciplinary measure, because the plaintiff showed no remorse and tried to minimize the impact of his remarks. So I think that this decision shows that now more than ever, employer must take psychological harassment very seriously and have the power, but also the obligation to implement severe disciplinary measure to put an end to such situation. So I think this decision is important because it's a key reminder that the courts are pretty severe regarding psychological harassment nowadays. We can go to the next slide, please. Okay, so the last decision I want to talk about is one that addresses an issue that is relevant to many companies that are currently in the process of defining their return to work or hybrid work policies. It's a decision that reminds employers to be cautious before terminating an employee who would refuse to return to work, following an order of the employer. And so the decision in question, it's Drake versus Équipement Transcontinental. And in that decision, the tribunal has ruled that an employee's refusal to return to work at the employer's establishment following a directive to end telework does not constitute a serious enough offense to justify dismissal. In that case, the employer terminated the complainant who held the position of purchasing and inventory clerk due to his refusal to return to work on site. The tribunal determined that the company did not have a permanent telework policy in place, and that the employer's management right allowed them to require employees to resume on-site work. However, while acknowledging the employee's refusal to comply with the employer's directive was a clear situation of insubordination, the tribunal concluded that this misconduct was not serious enough to warrant a dismissal, particularly given that the complainant had been open to further discussion on the issue, had 10 years of seniority, and had no prior disciplinary record. Therefore, the tribunal found that the employer had failed to demonstrate just and sufficient cause for the dismissal. So I think that this decision is important because employer should bear in mind that the disciplinary sanction that can be imposed on an employee who refuses to return to work, whether permanently or partially, must be chosen on a case-by-case basis. In general, the principle of progressive sanction should be respected, requiring the employers to take into account many things, amongst them the seniority of the employee in question, his position in the company, his disciplinary record, and so on. In the case of a person with a clean disciplinary record, it may be preferable to impose either a short suspension or a warning, and then increase the sanction as necessary. And so this completes the overview for the Quebec part, and it is now my pleasure to hand over to my colleagues from Ontario. Andy, it's your turn.
Great, thanks, Nicolas. And there's never any shortage of case law coming out of our tribunals or Superior Court and Court of Appeal in Ontario, and this summer was no different. We're going to highlight 2 human rights cases and then 1 class action. And you'll see in the chat too, our very good associate, Fatima Khan, has written a very comprehensive case review on at least 2 of these cases, and then you'll get a bonus 3rd if you go to our blog. And there's a lot of action on the blog these days with trying to make sure that we're keeping all of you up to date on what we think are both interesting and important developments that are going to be important and applicable to your workplaces. So if we go to the first case, we may have lived through the pandemic, but the case law from those days and mandatory vaccine policies continues to start to percolate now through the system. And this is a Human Rights Tribunal of Ontario decision. There was another mandatory vaccination policy case and dealt with an employee who had been dismissed, and the employee had relied on creed in seeking an accommodation or an exemption from the mandatory vaccination policy. And many of you will have remembered and know, or maybe you're still dealing with it, is creed became a very common basis for employees to seek accommodation as to why they were not going to be able to comply with the mandatory vaccine policy that the employer had implemented. And in this case, it was no different. And what the employee said in this case was that they were seeking the exemption on the basis that the COVID-19 vaccine alters in some fashion all or some of a person's genetic material, code, makeup, of all or part of their body or bodily systems. And what they then linked that to was this idea of bodily autonomy being central to the individual, and then referencing the creator. They weren't specific as to who or what the creator is. They just used this phrasing that the creator would protect them, and the belief that an individual's private life, medication, treatments, etc., should be kept as private as possible. And so what happened in this case is that the employer did end up terminating the employee's employment, and then the employee brought an application for discrimination based on creed. And if you go to the next slide, you can see some of the helpful rationale, because creed is broader than religion, and it was a difficult analysis for a lot of employers to go through to see whether or not the beliefs that were being advanced by particular employees would fall into the creed category under the Human Rights Code. And so this case is helpful because it provides a list of the factors that at least the tribunal would consider important. So whether or not the creed is sincerely, freely, and deeply held, It's integrally linked to a person's identity, self-definition, and fulfillment. It's a particular and comprehensive overarching system of belief that governs one's conducts and practices, addresses ultimate questions of human existence, and then has some nexus or connection to an organization or community that professes a shared system of belief. So here, the tribunal accepted that this was sincerely, freely, and deeply held, and I think also agreed that it was integral to that person's identity, self-definition, and fulfillment. Where the applicant in this case fell short was that there was no evidence of an overarching systemic component, and it didn't form or didn't appear to form any nexus to any organization or community with a shared system of belief. So there really just looked to be this singular belief, and that became a key point of analysis that employers had to engage in during the pandemic to find out, okay, is this person actually subscribing to a wider system of belief, or is it just a singular belief that is, I don't want to have a COVID vaccine? And in this case, the tribunal keyed in on that and said that it looked as though the applicant had not brought any other evidence. And so really all this was just a single belief that the COVID vaccine could alter DNA, and the need for autonomy would not carry them over the hurdle to say that this was an actual case of discrimination. So the case was dismissed at a very early stage. There was not a hearing. And so just another kind of interesting way of how the law has developed as we are hopefully on the other end of the pandemic. But these mandatory vaccination policies, they remain something that both courts and tribunals are grappling with. Next slide is more to a day-to-day kind of issue, and it probably comes up in every wrongful dismissal settlement, human rights settlement, harassment settlement that we come through. Is people are concerned about the confidentiality of the terms of the deal, and these are obviously very important terms in settlement agreements. And you can see in this case, these were the clauses that were at issue. There's a confidentiality clause, a mutual non-disparagement, a few other clauses that you'll see in Fatima's more comprehensive review of this case. But the key point was that the confidentiality clause said, upon inquiry by any person about the resolution of the application or conclusion of the applicant's employment with the applicant corporation, the applicant shall simply state that all matters have been resolved. The applicant will make no mention of or allude in any way whatsoever to the receipt of money or the amount of money received from the applicant corporation. So if you go to the next slide, you can see what happens. Right after the mediation and the settlement, the employee goes to LinkedIn and puts a blanket post up that just says, to all those inquiring, I've come to a resolution, my human rights complaint against the applicant corporation. And we're just using, consider that that's just the employer here, and myself, the individual, for sex discrimination. So what happens next is the employer sees this post. They actually ask the employee to remove it. The employee doesn't respond. Instead, what the employee does is they revise the post. And now it just says, to all those inquiring, all matters have been resolved in my human rights complaint against the corporation and the individual applicant, because there were two people that she had sued for sex discrimination. And so after that, the employer sought a ruling from the tribunal, and the tribunal agreed and said that the plain language reading of the confidentiality clause, and Peggy, maybe if we just go back to the previous slide so we can look at it. The confidentiality clause said upon inquiry. So it wasn't as though you could just go and post on LinkedIn to talk about what had happened in your case. Someone had to ask you before you could disclose where things were at with this particular matter. So Peggy, if you go back to the next slide. So in this case, what you had was a post that was publicly accessible. It includes references outside the scope of the permitted language of the confidentiality clause. And then there was a mutual non-disparagement clause that you could argue that the reference to sex discrimination could bring one or the other party into disrepute. And so the tribunal concluded that any reasonable and objective viewer would think that this type of a post could carry a real potential of serious reputational damage. And so what happens in this case is that the tribunal rules that the employee, the former employee and the applicant had to repay the settlement amounts. So the takeaway that you can take from this case, if you're an employer, is that there are mechanisms at the disposal of the employer or the respondent in any sort of case where you can move to enforce the confidentiality of a settlement term. And there are other cases that have been out there that we've talked about, both in the labor arbitration setting and also in the civil courts. But this recent decision, I think, is very helpful, given the volume of human rights cases that there are, that it's worth noting and thinking to yourself that, yes, you can be concerned about confidentiality, but there are ways to ensure that provision is enforced. So the last case is a class action. And class actions, if in Canada, as you know, are becoming more common. Generally speaking, with employers, they're focused on misclassification or some sort of technical non-compliance with the Employment Standards Act. And when the employee may, on its own, not have a very significant claim for, say, vacation pay, it can become much more significant if a lawyer can get a fairly large class together and then put a claim together and then get that claim certified as a class action. This was a misclassification case, and what it involved was about 2,500 individuals who were classified with the titles of branch rental manager, assistant branch rental manager, or station manager, all working at a rental car company. And in first instance, at the certification motion, the employer prevailed and said that the class action should not be certified, and the motion judge agreed and dismissed the certification motion. But the representative plaintiff appealed, and there was a number of kind of technical reasons as to why the representative plaintiff was still pursuing this. But the one that I think is most important and most applicable to employers on the call today is this idea of commonality. When you have a misclassification case, what the point of a class action is that it's supposed to be a common issue that can be ruled on by the judge that is going to affect the class all the same. And what the employer in this case argued was that, well, the assistant manager, the branch rental manager, the station manager, all of these people across Canada have very, very different duties, even though they may have the same title. And at the motion level, the judge completely agreed with that and said that in this case, we were looking at hundreds of branches, and they're all working in different types of venues. Some are working at airports, some are working at small branches in small towns. Others are very, very high volume branches. And so when you looked at that, the judge said, this is not a class that raises issues in the way that's envisioned by the Class Proceedings Act, because some of the members may very well be misclassified, but some are not. And we're going to need a factual basis for each determination that's going to happen on a case-by-case basis. So what happens is the employee appeals, and on appeal, the Divisional Court of Ontario agreed with the motions judge and effectively just said, like, the variability in the mix of work here, it just is not going to allow me as a single judge or whoever would be the presiding judge to make an issue or make a determination that would properly impact all of these various managers, because some had very, very different job functions, and some had a significant amount of managerial authority, some maybe did not have. And what the appellant was trying to do was say, well, we only need you to look at one particular item of the manager's duties, which is, do they have a significant level of autonomy and decision-making process? And that's actually the most important thing. But the appeal at the divisional court, they disagreed and said that, you have to look at everything holistically. So a very helpful case for employers as they worry about whether or not you could be vulnerable to a class action. Class action lawyers on the plaintiff side will obviously be very, very careful to ensure that the class that they're putting together has a significant amount of commonality. But where you have a large class, there may be an opportunity for employers to push back and say that, look, we may need to look at this issue, absolutely, but we will not be looking at it on a class action basis because there's just not enough uniformity amongst the class. So 3 cases that happened over the summer that I think are helpful and interesting to employers. And with that, I'm going to turn it over to Kristi, who's going to give you the update from Alberta.
Thanks, Andy. So I'll be walking us through some of the recent case law emerging from Alberta, and you'll see that some of the topics covered have been quite common across Canada, such as harassment and mandatory vaccination policies. So we'll start off with the first case. So this is the case, which is the first Alberta case to clearly recognize the tort of harassment. So this case centers around the defendant, Mr. Johnston, who had made numerous negative remarks to news outlets and on his radio show that were targeted towards the Alberta Health Services, and in particular, one health inspector, Miss Nunn. So while commenting on the public health measures surrounding COVID-19, Johnston would repeatedly engage in rants that would belittle Nunn. Some of the derogatory words used included terrorist and fascist, and he would often tell his followers statements such as, "I intend to make this woman's life miserable, and I intend to destroy her life and her family." And these rants were often accompanied by photos of Nunn and her family members, her husband and her children. So the plaintiffs asserted that Johnston's threatening and abusive conduct should constitute tortious harassment. Next slide, please. So this raised the question of whether a tort of harassment should be recognized in Alberta. The court had looked to Ontario and British Columbia to see what those provinces had done, and noticed that both provinces had not recognized the existence of a tort of harassment. However, the Alberta court felt that recognizing a tort of harassment was justified. And in justifying the tort of harassment, the court looked at some considerations that you can see there on the slide. The first one being that existing torts, such as the tort of intimidation or the tort of private nuisance, didn't fully address the harm caused by harassment. And so a tort of harassment could fill a gap in the law. The court also looked to the criminal code and noted that while not every criminal offense had a corresponding civil remedy, the court did feel that it was reasonable to consider whether there should be a civil remedy for harassment. Another consideration was the fact that the Court of King's Bench of Alberta regularly grants restraining orders to prevent harassment. And the volume of these orders indicated that harassment was a big issue, and recognizing a tort of harassment would allow damages to be awarded in such circumstances. Lastly, the court also noted that the Alberta legislature had the power to modify any common law torts, or potentially down the road create a standalone statutory right of action for harassment. Next slide, please. So in recognizing the tort of harassment, the Alberta court defined it as a defendant has committed the tort of harassment where they've engaged in repeated actions or behaviors that are harassing, and that the individual should have known that such behavior or actions would be unwelcome and cause a reasonable person to fear for their safety, and it would cause harm. So in going through this test, the court was satisfied that Johnston had committed the tort of harassment, and Ms. Nunn was awarded $100,000 in general damages for harassment. Next slide, please. So some key takeaways from this decision is that as a result of now recognizing a tort for harassment, this adds another avenue for claimants or employees to obtain compensation for harassment. And employers should be mindful of the potential vicarious liability that could arise based on the conduct of one of their employees. Now, this decision is a good reminder to employers of their legal obligations under occupational health and safety legislation. Similar to what Nicolas touched upon in Quebec, employers have a duty to ensure that their workplaces are free from harassment, and the legislation actually requires them to have policies and procedures in place to support this. And so it's key for employers to make sure that they're reviewing these policies and procedures and making sure that there are the mechanisms in place to respond to complaints of harassment and to make sure that they're investigating these complaints, as these will likely be an employer's strongest defense if there is an employee who is claiming the tort of harassment. Next slide, please. So the next case deals with mandatory vaccination policies, and this is a decision from the Alberta Labour Relations Board of an appeal of an employment standards decision. So this case involves an employee who did not wish to be vaccinated and as a result was not in compliance with her employer's mandatory vaccination policy. So her employer, the Calgary Climbing Centre, or CCC, had imposed this policy as a way to keep its doors open during the pandemic, while also making sure they were looking after the health and safety of their employees and their clients. So those employees, including Jones, who did not comply with the policy, were placed on an unpaid leave. And the employer did indicate that this was a temporary leave, and if other suitable safeguards were found or if the pandemic died down, that these employees would be recalled from their unpaid leave. Jones alleged constructive dismissal and filed an employment standards complaint. Now, while the parties were in the process of going through this complaint, COVID-19 restrictions in Alberta were loosened a little, and the centre did recall employees who had been placed on the unpaid leave, with the exception of Jones. Next slide, please. So the board found that placing employees on an unpaid leave for failing to comply with the mandatory vaccination policy did not constitute constructive dismissal. They found that the employer's actions during those uncertain times, given all the circumstances, were reasonable. And so that specific action of placing those employees on an unpaid leave did not come to constructive dismissal. And in coming to this decision, the board did look at some other cases, such as a BC case that determined that the introduction of a vaccination policy in this context does not amount to constructive dismissal, as well as an earlier board decision that found that employees did have the right to choose not to be vaccinated, but those employees would have to accept the consequences of that choice. However, it is important to note that the board did find there was constructive dismissal in the employer's actions of failing to recall Jones once they had recalled the other employees. So if a suspension is to be continued, it has to be justified. And they found that the employer had not justified Jones' suspension. So while the employer had said, well, she filed a complaint against us and we took it as, she was resigning, the board found that that was ambiguous. And as an employer, the center did have an obligation to seek clarification. So the key takeaways for employers from this case is, as Andy mentioned, COVID-19 seems to be an issue that will unfortunately be sticking around. And this decision provides some clarity when dealing with unpaid leaves for non-compliance with mandatory vaccination policies. And it's important to note that the circumstances and contextual background surrounding the time that the policy is imposed will always be important in considering whether or not an employer's decisions are reasonable and justified. Next slide, please. Now, this last case that I'll be discussing deals with termination clauses. So the employee in this case had been terminated without cause, and he was paid the amounts pursuant to the Alberta Employment Standards Code. The employee then claimed that he was entitled to more than just those amounts under the code, and demanded for additional notice pursuant to the common law. So a long-standing principle is that employment contracts are presumed to contain an implied term requiring an employer to provide reasonable common law notice of dismissal. However, this presumption can be rebutted through clear and unambiguous language in a termination clause. Next slide, please. So the court then looked at the language of the termination clause in question and found that it did not meet the test. It was not clear enough to oust that common law presumption. So specifically, the inclusion of the words "or such additional notice" that was found in that termination clause was language that would have entitled the employee to more notice beyond those amounts under the code. And it didn't set an upper limit on the employee's notice entitlement. And as such, this employee was found to be entitled to common law reasonable notice. Next slide, please. So some key takeaways from this case is that termination clauses are very important, but very tricky. And this is because a lot of the case law in Alberta regarding termination clauses will tell you what type of language does not extinguish that common law reasonable notice right, but the cases won't exactly tell you, here's the language you should use instead. And further, as most employment contracts are drafted by the employer, any level of ambiguity will be interpreted against the employer. However, the existing case law on this issue does provide enough guidance on types of languages that are clear and unambiguous. Examples including stating an upper limit on the amount of notice, explicitly stating that this is the amount of notice that the employee is going to get and nothing more, and also emphasizing that the notice entitlements under the code will be full and final satisfaction of all rights or entitlements, and no claims in common law will be permitted. And with that, that wraps up the Alberta updates, and I'll pass it over to Jeff.
Great. Thanks very much, Kristi. So I'm going to be talking about two BC cases which came out over the summer in which the employer was successful defending some wrongful dismissal claims, and then I'll briefly touch on the BC Pay Transparency Act, which was passed in May, and it brings some additional requirements into force as of November 1st. So we go to the first, next slide, please. The first case is Chura and Batten Industries, which is one of those relatively rare cases where just cause was alleged and made out by the employer. It's a long decision with more than 300 paragraphs, but it demonstrates the type of misconduct and dishonesty that can amount to that high standard of just cause. And so in this case, the employee and her husband were friends with the owner of the defendant company. And after 9 years of employment, some suspicions were raised about expense reimbursements that she claimed and other conduct that generally relating to obtaining personal benefits at the company's expense. So she was terminated for just cause and sued for wrongful dismissal, and the employer counterclaimed for the losses related to the misconduct. There was a fairly long list of allegations that the employer said amounted to cause. And so some of those included dishonestly claiming expenses. So, for example, she went to a business dinner with a client and a colleague, and although the client paid for the dinner, she took the check from the table and then subsequently submitted it. She submitted receipts for room service meals that she didn't pay for, was actually charged to the company credit card, got reimbursed for some apparently bogus US custom fees, and was reimbursed for a bike rental in New York to bike around Central Park, which was for personal purposes, but came out that she emailed that receipt with an email saying something along the lines of, we didn't get stuck in traffic and this was way better than taking a taxi. So it's sort of appearing to cover up that this was for a personal purpose. There were allegations that she was trading company products for her own personal benefit, and this was actually one of the grounds that wasn't found to be improper. In her role, she was traveling to different trade shows, and it was fairly accepted practice for attendees to trade their products, although the judge did note that she was obtaining a personal benefit from that. She was corporate accounts for her personal benefit, so purchasing a printer and phone charging cable from the company's Staples account, using the company's shipping transport to transport personal items across the border, and passing off the cost of duties and shipping fees. There was an allegation about charging her family's cell phone bills to the company, and that one wasn't found to amount to misconduct because the company didn't have a formal written policy and actually knew that this was a family plan, and she had submitted partial cell phone bills, and the company never requested complete copies, and so that wasn't found to amount to misconduct. And then the sort of most serious one, at least in the judge's opinion, was that she caused the employer to enter into a contract with a website company, and that company provided a 20% kickback to the employee's husband. So that was sort of the main thing. And if we can go to the next slide, the website company kickback was actually sufficient to constitute just cause on its own. So this was a kickback that the employer was not aware of. And so the court referred to the leading case of McKinley and BC Tel with respect to termination for cause, which calls for a contextual approach to the question of whether the employee's actions may reasonably said to have given rise to a breakdown in the employment relationship. And that case says, it makes clear that not all acts of dishonesty are sufficient to constitute just cause. And the particular facts and circumstances of each case should be examined, considering the nature and seriousness of the dishonesty in order to assess whether it can be reconciled with sustaining the employment relationship. So the court concluded that the website company kickback was sufficient on its own to constitute just cause because the employee's dishonesty and self-dealing went to the heart of the employment relationship and was fundamentally and directly inconsistent with her obligations to the employer. And so the facts were that the employee actually hid that her husband was being paid by the website company, and that there was a detriment to the company as a result of these actions because there's a presumption that the company paid a higher price given that 20% kickback. And so her failure to disclose this conflict was held to be a breach of her fiduciary duties, but the court said that even if she wasn't a fiduciary, it was a breach of her common law employment duties of good faith and honesty to her employer. An interesting takeaway from this case is that the court commented that some of the other misconduct that might be characterized as negligent rather than dishonest. So, for example, the failure to ensure that she wasn't reimbursed for expenses that had already been paid for by the company, like those room service charges. There was also some charges for her daughter going to Las Vegas with her for a trip that she didn't make sure that she wasn't reimbursed for. And her failure to ensure that she actually repaid the company for personal items that she purchased on the Staples account. The judge commented that those forms of misconduct taken in isolation likely would not reach the level of just cause, but in this case, taken together with the other forms of misconduct, and there was a pattern of dishonesty and deceptive behavior that was inconsistent with the continued employment relationship. So in that case, just cause was made out. And if we could go to the next slide. So the court found in favor of the employer and actually awarded about $16,000 to the employer for its counterclaim to recover amounts that she had improperly received. And then just as a side note on this case, it was perhaps as a cautionary example of how litigation can proceed somewhat unexpectedly. The trial was supposed to take 5 days, but it ended up taking 23 days over the course of 1.5 years. So certainly ballooned to 23 days, as the court put it. And so that's a costly endeavor. And the costs were not dealt with in the decision. The judge left it up to the parties to try to agree to costs, but the employer was seeking special costs. So that was not decided in the case. We go to the next slide, please. The second case that I thought was interesting is Kangura and Lumber West Building Supplies. And this is a case dealing with the question of whether the employee resigned or was terminated. So the employee was a building supply and lumber salesman who'd been with the company for about 10 months. And the company had some concerns with his performance. And on the other side, the employee was unhappy with the state of the company's operations. So the company attempted to engage in performance coaching, sent some emails, and one of those emails the employee interpreted to mean that he was being terminated without cause. And so for reasons that I'll touch on, it's important in this case that there is a termination for cause provision that they had in their written employment agreement. And what that said was that the employer could terminate for cause in the event of any failure by the employee to perform or observe any of the provisions of this agreement where such failure is not cured within 30 days of written notification to the employee. And I've underlined that second part there because that is an important factor in the decision. So we can turn to the next slide. So after several warnings and attempts at performance improvement, the employer sent 3 emails over the course of August 4th to 12th, so a few days. And the first email, these are just excerpts, so they're longer emails, but the first email says that to the employee, if you do not follow the directions of the president and or the director of Lumber West Building Supplies, the company will then have the right to terminate your employment agreement for cause as per Article 6.2a, and that's the clause that we just looked at. Then a week later, there was a second email where the employer said, we've provided enough warning to follow the terms of your employment agreement. You have continued to refuse to do so. As such, please consider this as our 30 days written notice to terminate our employment services agreement. And so this is the email that the employee interpreted to be a clear intention to terminate his employment without cause. And then the next day, the employer sent the third email, and that included the statement that as per my email that was sent to you on August 4th, that was email number 1, I've made it very clear regarding your duties, work time schedule, and daily sign in and out. Again, you've continued to refuse instructions set out by the director of the company. Please refer to the attached email from August 4th, and that's that first email. Next slide, please. So the employee in response retained a lawyer who wrote a letter asserting that the company was terminating the employee's employment. And then what followed was a course of communications over the next weeks from the company and its counsel that made clear that the company did not intend to terminate his employment and in fact wanted him to continue his employment. So there are 3 excerpts from letters or emails that I've included here, which followed from September 3rd to 23rd that clarified the employer's position. In the interest of time, I won't go through all of them, but basically the employer was saying there was no intention to terminate this employee's employment, but instead it was actually providing that period of 30 days to address the concerns that had been raised with him regarding his performance. And so, in fact, he was not terminated. We were giving him 30 days to improve and was referring to the termination clause. And so there's also an email from the company itself that specifically said they want the employee to continue working. Your position remains available for you. We have not terminated your employment. And then also even goes as far as apologizing and saying, I understand how my email of August 11th could have been misconstrued, but I want to emphasize again that it was not my intent to terminate your employment. And then it goes beyond that. It says, in recognition of this error in communication, Lumber West is prepared to make good on any lost salary sustained between your last day of active work and the date of your return. And I think that's important often in cases where an employer is trying to say, come back to work, you should continue to be working for us, is making them whole if they've been off work for a period of time. So if we can go to the next slide, please. So the court concluded that the employee was not terminated, but instead he'd actually voluntarily left his employment. The court affirmed the test for determining if an employer dismissed an employee is purely objective. And so the employee's subjective understanding of the employer's intention is not determinative. Instead, there must be a clear and unequivocal act by the employer that objectively viewed amounts to dismissal, and which would be understood as such by a reasonable person. And so the court also noted that the evidence of the surrounding circumstances may be considered. And so in this case, the court's analysis, the court held that the second email could not be considered in isolation. So the emails before and after that spoke to the performance issues and termination clause, Article 6.2a, which contemplated termination for cause if there wasn't improvement after a 30-day period. So that second email, the court says, should be considered in that context. And then the court also agreed that the emails were confusing, but this was remedied by the fact of the company's subsequent correspondence. And in light of that clarification, it was not reasonable for the employee to maintain that the position that he was terminated without cause. And if we go to the next slide, please, I'll just touch briefly before turning things back to Andy on a legislative update in BC that received royal assent in May, so just before the summer holidays, and it's the Pay Transparency Act. In May, all the provisions except for one came into force, and that last one is coming into force on November 1st. And so the act, it does a few things. One of the things it does is it prohibits employers from taking certain prohibited conduct. And so employers cannot seek pay history information about job applicants by any means. And so employers cannot ask applicants about their pay history or seek that information from other parties unless it's publicly accessible. And then additionally, the act provides protection from reprisal by employers against employees if the employees do things such as ask the employer about their pay, if they disclose information about their pay to another employee or applicant. And I think that's probably one of the main ones that, employers that have policies or tell employees not to tell others about their pay. That's, I think, one of the main ones to be aware of. No reprisals for employees asking about a pay transparency report, which I'll talk about, or for asking the employer to comply with their obligations under the Pay Transparency Act, or giving information to the director of pay transparency about their employer. November 1st is what is next on the horizon, and the provision that comes into force on that day provides that employers in BC must specify the expected pay or the expected pay range for any publicly advertised job opportunities. So that's something to keep in mind in about a month's time. If we go to the next slide, please. The reporting requirements that I mentioned have also been introduced by the Act. And under these requirements, employers will be required to prepare an annual pay transparency report each year. And the report will need to be distributed to employees and posted to a publicly accessible website. Although the details for these reports are still being developed, they will include information about the employer, the composition of the workforce, differences in pay in relation to employees' self-identified gender and other characteristics, and then any other information that the regulations might prescribe. So currently, this reporting requirement only applies to the government of BC and 6 Crown corporations like BC Hydro, ICBC, but they will be introduced for employers moving forward over the next few years based on the size of employers. So eventually it'll get down to employers of smaller sizes, but it starts next year with 1,000+ employees and goes from there. So with that, I will turn it back to Andy for Q&A.
Great. Thanks, Jeff. And thanks, Kristi and Nicolas, for really, really helpful presentations. We don't have a lot of time left, but there is a bit of time to go through a couple questions. And one question that came up in the Q&A was, well, isn't this all criminal harassment? And very good point. There is a distinction to be made between criminal harassment and civil harassment. The harassment that we're usually concerned about the most in our realm of the law is in the labor and employment context. Those harassment prohibitions usually pop up in the occupational health and safety legislation. And so that then makes it a civil case. What Kristi spoke about today is something very interesting in terms of this new idea that it's just a civil claim, that it's not just drowned in statute. So wanted to quickly address that. A lot of questions coming in right now about the BC Pay Transparency Act, and very good point that has been raised. Jeff, if you can just quickly, is it 1,000 employees in BC or is it 1,000 employees across Canada?
Good question, because it's one I had myself. And my assumption, understanding based on what we know so far, is that it would be BC. So the bill, as it says, it just says 1,000 or more. It doesn't say where, but on the government's website about what employees must be included in the pay transparency reports, it says the requirements apply to all of the organization's employees in British Columbia. And so I think that is my understanding, at least at this point, until we get more clarification, that would be the BC numbers.
And we'll do another quick question on the pay transparency. We may have to do another webinar just on that topic alone. Are we looking at companies that are incorporated in BC, or is it that they operate in BC?
I believe it would be operating in BC.
Yeah. Which would be consistent with how employment standards legislation works. We're not worried about, is the company incorporated in Ontario? We're worried about, are you conducting business in Ontario? So very good questions on the pay transparency, and I think we will probably look to provide a bit more guidance as we get closer to the big deadline in 2026, when it's everyone over 50 employees. Kristi, I thought your webinar was really helpful with respect to the termination clause enforceability. In Ontario, people on the call will know that judges are increasingly suspicious of any sort of termination provision, and it's it's getting very difficult to enforce them. Not impossible, but difficult. Alberta has generally been a bit more friendly to termination provisions, but your case now obviously maybe shows a shift in thinking. So just wondering if you could give a market kind of comment to our listeners about whether or not they should be a bit more concerned that Alberta may start to adopt the Ontario model.
Yeah, and I definitely think so. I think we have a lot of cases here where the courts are a bit nitpicky with the employer's language used in their termination clauses and a bit more favorable to the employees. So it's extremely important to make sure that there's a very strong, clear, unambiguous termination clause. And, you know, when we get asked to review an employment contract, the first thing we look at is, okay, let's start off with the termination clause because of all these cases we're seeing where they're just saying, nope, this one is not clear enough. Nope, this one's not clear enough. So I think it's definitely a very important aspect that an employer needs to consider.
Great. Well, we're reaching the top of the hour. So Nicolas, I think, has been able to escape without any tough questions for Quebec. But thanks to all of our speakers, and thanks again to all of you who tuned in. I really want to encourage you to go to the blog. There's a lot of content that is now flying up on that website, including stay tuned for a very good post by one of our really great summer students, Placido Lunga, who is now back at law school, but worked very hard on a blog post involving the class action that I spoke about. So you'll want to be able to tune in to read that. Otherwise, this presentation has been recorded, and like I said at the outset, you'll be able to get the materials and access the recording either through the post-event email or on our website. Our next webinar is slated for October 27th. We're always interested to hear from you if there are particular topics that your workplace is dealing with on a more frequent basis. So please do let us know if there are particular topics that you would like to cover. We'd be happy to do so. And beyond that, we hope that you are able to find some time to reflect on our National Day for Truth and Reconciliation tomorrow. And we hope that you have a safe and happy weekend. Thanks again, everyone. Bye-bye.